People of the Philippines versus Lucky Enriquez, GR 264473. Facts. According to the prosecution, at 4:30 p.m. of May 3, 2017, the PDA Regional Director Villanueva conducted a briefing for the implementation of search warrants 5367, 2017, 5368, 2017, and 5369, 2017, all of which were issued by the executive judge of the RDC of Quezon City. Search warrant 5368, 2017, was issued against Espando, Freddy, and Enriquez at Informal Settlers Compound, Nia Road, Barangay Pinahan, Quezon City to search for and seize 1. Undetermined quantity of shabu/dangerous drugs, and 2. Drug paraphernalia. The team for the implementation of search warrant 5368, 2017, was composed of 30 PDA agents, with Agent Sulit as the team leader. Agent Banago was assigned as the arresting officer. Agent Million, as the seizing officer, was charged with searching the house described in the search warrant, which was allegedly a drug den operated by Espando, Freddy, and Enriquez. The PDA coordinated with the Quezon City Police District and secured the attendance of the required witnesses under Section 21 of RA 9165. At 5:30 p.m. that same day, the PDA team proceeded to the target area, where the confidential informant directed them to the subject house. When they arrived at 6 p.m., Agent Sulit entered through the open door of the house. Some of the other PDA agents followed him inside and went upstairs, while the others remained on the first floor. The PDA agents looked for Espando and Freddy, but they were nowhere to be found. Enriquez, who was on the first floor, was immediately recognized. Upon seeing the PDA agents, Enriquez ran to the second floor of the house. However, Agent Banago caught him and brought him back downstairs, where he was arrested and handcuffed. Agent Million presented the search warrant to Enriquez, informed him of his constitutional rights, and explained their authority to search his house. The search was witnessed by Media Representative Mendoza of DZAR Sunshine Radio and Barangay Kagawad Bernal of Barangay Pinahan, Quezon City. Agent Million searched the first floor of the house. He found a blue pouch with the brand Kipling at the top drawer of a blue-gray plastic cabinet beside an altar. Said pouch contained the following: 26 transparent plastic sachets containing white crystalline substance, 1 improvised tutor, 2 pieces of disposable lighters, several strips of aluminum foil, 1 pair of green scissors, and 1 empty transparent plastic sachet. Agent Million marked and inventoried the seized items and prepared the certificate of orderly search, while their photographer, Charlie Magno, photographed the seized items and the conduct of inventory. The inventory and taking of photographs were witnessed by Mendoza and Kagawad Bernal. First, whether search warrant 5368, 2017, issued against appellant Enriquez was valid, and second, whether the PDA properly executed search warrant 5368, 2017, held. The Constitution guarantees the fundamental right against unlawful searches and seizures, which is sacrosanct and inviolable. Article 3, Section 2 thereof provides, Section 2, the right or the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature, and for any purpose shall be inviolable, and no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. It is for this reason that Article 3, Section 3, Paragraph 2 of the Constitution mandates that any evidence obtained in violation of these rights shall be inadmissible for any purpose in any proceeding. In other words, evidence obtained and confiscated on the occasion of such unreasonable searches and seizures are deemed tainted and should be excluded for being the proverbial fruit of a poisonous tree. Among the requirements for a valid search warrant is that it must particularly describe the place to be searched. This requirement is essential in the issuance of search warrants to avoid the exercise by the enforcing officers of discretion to decide on their own where to search and whom and what to seize. The description in a search warrant complies with the constitutional requirement if it meets the following criteria. A description of a place to be searched is sufficient if the officer with the warrant can, with reasonable effort, ascertain and identify the place intended and distinguish it from other places in the community. Any designation or description known to the locality that points out the place to the exclusion of all others, and on inquiry leads the officers unerringly to it, satisfies the constitutional requirement. In this case, Search Warrant 5368, 2017, S description of the premises to be searched is located inside the subject house. Please see attached sketch map of the house, located at Informal Settlers Compound, Nia Road, Barangay Pinahan, Quezon City. Clearly, the search warrant's wording fails to meet the particularity requirement, as it effectively gave the PDA agents free rein to search every place within the Informal Settlers Compound in Nia Road. The procedure is clear. Government agents must announce their presence, identify themselves to the accused and to the persons who rightfully have possession of the premises to be searched, and show to them the search warrant to be implemented by them and explain to them said warrant in a language or dialect known to and understood by them. If the government agents are refused entry despite their compliance, then they have the right to break open doors or windows. Further, government agents may execute an unannounced intrusion under limited circumstances. Regarding the conduct of the search, Rule 126, Section 8 of the Rules of Court provides a hierarchy of who are prioritized as witnesses. This witness must either be the lawful occupant of the premises to be searched or any member of their family. It is only in their absence that individuals of sufficient age and discretion residing in the same locality may step in as witnesses. Corollarily, a search where the witnesses prescribed by law are prevented from actually observing and monitoring the search of the premises violates both the spirit and letter of the law and renders the search unreasonable. In this case, it is undisputed that the police agents entered appellant's house without permission and any announcement of their presence. The lower court's narration of facts is consistent that upon seeing that the door to appellant's house was open, the PDA agents immediately rushed inside without making any effort to give notice of their purpose and authority to execute the search warrant and request entry. The government agents only undertook these actions once they were inside and saw appellant, who was very much surprised at their presence. The prosecution failed to justify the PDA agents' unannounced entry into appellant's house. A scrutiny of the narration of what transpired prior to the government agent's entry reveals the absolute absence of any reason that could necessitate a circumvention of the requirements of Rule 126, Section 7 of the Rules of Court. First, the government agents never sought appellant's permission to enter his house, giving him no opportunity to refuse. Second, as appellant did not see them before they entered, he was unaware of their authority and identity. Third, there is no showing that the government agents believed there was an imminent peril to life or limb. Finally, the prosecution never claimed that. Prior to their entry, the government agents were under the impression that appellant was trying to escape or destroy the evidence to be seized. While appellant ran away when he saw them, this act may be attributed to a shock upon waking that several strangers were suddenly inside his house, and not an indication of guilt. It is clear to this court that the search conducted on May 3, 2017 was executed in violation of the appellant's constitutional rights and the rules of court, rendering it void. Concomitantly, the items seized from the search are inadmissible as evidence for any purpose in any proceeding and may not be used against appellant to support his conviction in the present case. Therefore, his acquittal is in order.